Hi, James Polk here from Apex Law Service, and today we're going to be talking about two Supreme Court cases from 2018. It's 2019 right now, so these are relatively new cases. They both have to do with the Fourth Amendment. It's Byrd v. United States and Collins v. Virginia. Collins v. Virginia is a case where a motorcycle rider was driving about 140 miles an hour. Police officer saw them, got a picture of the license somehow, chased him into a neighborhood. The motorcycle rider was able to lose the police officer. The police officer found a motorcycle under a tarp, and the officer walked up the driveway to the house where the tarp was, lifted up the tarp, saw the license plate. The guy had to defend himself against a criminal case. It was his girlfriend's house, and the arguments all had to do with whether the vehicle exception to the Fourth Amendment requirement for a search warrant trumped the curtilage rule. Now, the vehicle was within a number of feet of the house and considered to be inside the line of demarcation of curtilage, and therefore it is the same. Anything in that area is the same as being in the house. So a Fourth Amendment violation actually ended up occurring is how it came out in the Supreme Court. So it was an 8-1 decision. Justice Samuel Alito felt there was nothing unreasonable at all, but the rest of the justices said that it was too intrinsic of a constitutional law issue to intrude upon the already determined and already set rules about curtilage, that it just was too much of an invasion into people's homes. So the other case is Byrd v. United States. This case is a lot different. This guy wasn't just driving really fast. He was, the motorcycle was stolen, by the way, but that's a different element of the case. This guy wasn't just driving fast in a stolen vehicle. He was pulled over and his trunk was searched, and he was found with body armor and heroin. And it was a rental vehicle, and he was driving 10 and 2 like this, and it looked out of the ordinary to the law enforcement officer. Their instinct proved to be some form of right. I don't know if the guy was really nervous because of what was in the trunk, so he was driving. I mean, that's what they thought it looked like, and then there was something there, but he was not the person on the rental agreement, and therefore they did not feel that he had the reasonable expectation of privacy, and that they did not need his consent to search the trunk. The Supreme Court ruled unanimously that he did have the reasonable expectation of privacy because of the law of property, that the person who was on the rental contract had the right to possess the vehicle and use the vehicle, and they also had the right to let somebody else, not by the rental contract, but it just was not a violation of property law and criminal law. It wasn't a stolen vehicle, so that case went that way because of that issue. Those are two Fourth Amendment issue cases that you can read about in the blog below. Also, there's links out to the cases, to some summaries of the cases, and to another blog, and to another publication, a police publication actually, that was talking about the cases before they were decided. So that's actually how I found these two cases specifically. I've heard of the issues. I had heard the issues brought up, but these two cases I hadn't yet to read them until today. So hope you enjoy reading the blog, and thank you again for checking out Apex Law Service. James Polk. Have a great day.